Welcome, everyone. In this masterclass, we're going to break down Article 1 of the Indian Constitution, a topic that is absolutely critical for your exams. What does it really mean for India to be a union of states? It sounds simple, right? But believe me, its wording was intensely debated, and it has defined a balance of power between the central government and the states ever since.
So here's our game plan. We'll start with the actual text of the article itself. Then we're going to tackle that core debate. Why is it called a union and not a federation? From there, we'll understand India's territory as the Constitution defines it, review a couple of key cases you just have to know, and then we'll finish up with a summary to help you absolutely ace your answers.
Okay, let's dive right into it. We're going to start with the foundational text of Article 1, because remember, in constitutional law, every single word matters.
Now, notice the very specific wording here. India, that is Bharat. The Constituent Assembly didn't just pick one name. They deliberately included both, giving them equal constitutional status. This was way more than just a matter of translation. It was a profound statement about national identity.
And then you get the second half of that clause, shall be a union of states. This is where the real legal action is. This phrase wasn't picked out of a hat. It was fiercely debated, and it fundamentally defines the very nature of the Indian state. If you can understand this, you've understood the key to this whole topic.
So, that specific phrasing, union of states, immediately brings us to the most frequently asked question on this topic. It's really at the heart of understanding India's entire political structure.
This is a classic exam question, folks. Why a union and not a federation? The answer tells you everything about the vision that the framers of the Constitution, especially Dr. B.R. Ambedkar, had for India.
And here is the answer you absolutely must cite in your papers. It's Dr. Ambedkar's own explanation. He made it clear that the Indian Union is not like the USA. It wasn't formed by an agreement between states. And because of that crucial fact, no state has the right to just pack up and leave. The Union is, by its very design, indestructible.
Now, this table does a fantastic job of laying it all out. It contrasts India with a classic federation like the United States, and the differences are just crystal clear. Look at this. India's union was created by the Constitution, not an agreement. Our states are subordinate to the union, not co-equal sovereigns. Secession, not an option. Parliament can change state boundaries on its own. And, of course, we all have single citizenship. It all points to one thing, a powerful central authority.
So, what do you call this kind of unique structure? Well, the most accurate term, and you'll want to remember this one, comes from the scholar K.C. Weir. He called India a quasi-federal state. It's a hybrid, you see, not purely federal, not purely unitary. And that term just captures the balance perfectly.
Okay, so now that we've got a handle on the political nature of the Union, let's switch gears and define its physical scope. What actually makes up the territory of India? Article 1, Clause 3 tells us exactly that.
Article 1.3 is pretty straightforward, but you have to be precise. It lays out three distinct components that make up the territory of India. You have the territories of the states, the union territories, and then this third very interesting category, any other territories that India might acquire down the road.
Now here is a detail where a lot of students get tripped up, so pay close attention. The term territory of India is actually a much broader concept than the Union of India. The Union only refers to the states, but the territory, well, that includes the states, the Union territories, and that forward-looking idea of any lands that might be acquired in the future.
And you know, this whole acquired territories thing isn't just some abstract legal theory. We have clear historical examples to prove it. After the Constitution was already in place, territories like Goa, Pondicherry, and later Sikkim were acquired and became part of India.
Okay, the textbook theory is one thing, but law really comes to life when you see it applied. So let's look at how the Supreme Court has interpreted these principles in a couple of landmark cases. You absolutely have to know these to understand the real power dynamics of the Indian state.
First up is the real heavyweight case on the union-state power dynamic, State of West Bengal versus the Union of India. So what happened was the central government passed a law to acquire some coal-rich lands that were owned by the state of West Bengal. The state, of course, challenged this, basically arguing, hey, we're a sovereign entity in a federation. You can't just take our property.
And this put the fundamental question squarely before the Supreme Court. Is India a true federation where the states are co-equal sovereigns with the Union? Or is the power structure different?
And the court's answer?
It was unambiguous. The Supreme Court held that no, India is not a true federation. The states are subordinate to the Union, and they do not have their own independent sovereign status. This ruling was a massive judicial stamp of approval on Dr. Ambedkar's Union of States principle.
All right, next, let's flip the script. We've seen how India can acquire territory, but what about giving it away? This brings us to the famous Barbari Union case. Here, the Indian government had made an agreement to transfer a small piece of territory in West Bengal over to what was then East Pakistan.
So the question for the court was all about process. Can the government just sign a deal and hand over a piece of sovereign Indian territory, or does an act that's significant require a formal, full-blown amendment to the Constitution itself?
And again, the court was decisive. It ruled that giving away sovereign territory, what we call cession, is so fundamental that it can't be done with a simple executive agreement. Nope, it requires a constitutional amendment following the tough procedure laid out in Article 368. And in fact, Parliament then had to pass the Ninth Amendment to make that transfer legal.
All right, let's synthesize all of this. We've covered a lot of ground, so if you're getting ready for an exam, this is the part you really want to lock in. These are the key principles from Article 1 that are absolutely essential to remember.
Think of these as the 4 non-negotiable points for a perfect answer on Article 1. First, you have to bring in Dr. Ambedkar's powerful concept of the indestructible union. Second, use the term quasi-federal to describe India's structure. Third, you must cite the state of West Bengal case to show that the union is supreme. And fourth, you have to cite the Barbari case to explain the strict rule for ceding territory. You hit those 4 points, and you're demonstrating a masterful understanding.
And that brings us to the end of our lecture. But I'll leave you with a final thought to chew on. This whole principle of an indestructible union was legally cemented way back in the 1960s. So the question is, how do you see that foundational idea shaping India's often fierce center-state political debates today? It's a question worth considering.